Okay, welcome back to Cracking the Code, 3rd edition. We are in the glossary. We are on O and P. Starting with oath. Oath, an affirmation of truth of a statement which renders one willfully asserting untrue statements punishable for perjury. An outward pledge by the person taking it that his attestation or promise is made under an immediate sense of responsibility to God, a solemn appeal to the Supreme Being, an attestation of the truth of some statement. Black's Fifth. Obligation, not defined in the UCC. Obligee, one who is entitled to receive a sum of money or to have an act or a deed performed as promised or agreed to by the obligor. Barron's Third. Obligor. Obligor means a person that with respect to an obligation secured by the security interest in or an agricultural lien on the collateral, 1. Owes payment or other performance of the obligation, 2. Has provided property other than the collateral to secure payment or other performance of the obligation, or 3. Is otherwise accountable in whole or in part for payment or for performance of the obligation. The term does not include issuers of nominated person under a letter of credit. UCC 9-102A59. One who has promised or is otherwise obligated to perform an act or deed, such as the payment of a sum of money under a promissory note or other contract. Barron's Third. Offer, a proposal to do a thing, a proposal to make a contract, also an attempt. Black's First. Order, in a general sense, a mandate, precept, a command or direction authoritatively given, a rule or regulation. In practice, every direction of a court or judge made or entered in writing and not included in a judgment is denominated an order. An application for an order is a motion. An order is also an informal bill of exchange. It is further a designation to whom a bill of exchange or negotiable promissory note is to be paid. Black's First, see note. Note, none of the above definitions are incompatible with each other as regards the courtroom setting. The order of the court is a pecuniary mandate for funds and is directly related with charges. In this sense, it is not dissimilar with a money order. Organization. Organization includes a corporation, government or governmental subdivision or agency, business trust, partnership, or association, 2 or more persons having a joint or common interest, or any other legal or commercial entity. UCC 1-201-28. See note. Note, the term applies when 2 or more persons are involved in a specific commercial contractual relationship, as well as with any other entity involved in commerce. All, quotes, individuals, that is to say all strawman trade names, fall under the definition of organization. Order. Order means a written instruction to pay money signed by the person giving the instruction. The instruction may be addressed to any person, including the person giving the instruction, or to 1 or more persons jointly or in the alternative, but not in succession. An authorization to pay is not an order unless the person authorized to pay is also instructed to pay. UCC 3-1036. Original debtor. Original debtor, except as used in subdivision C of section 9310, means a person that, as debtor, entered into a security agreement to which a new debtor has become bound under subdivision D of section 9203. UCC 9-102A60. Party. Party means a party to an instrument. UCC 3-103-8. Passport. In international law, a document issued to a neutral merchant vessel by her own government during the progress of a war and to be carried on the voyage, containing a sufficient description of the vessel, master, voyage, and cargo to evidence her nationality and protect her against the cruisers of the belligerent powers. This paper is otherwise called a pass, or a sea pass, a sea letter, or sea brief. A license or safe conduct issued during the progress of a war, authorizing a person to remove himself or his effects from the territory of one of the belligerent nations to another country, or to travel from country to country without arrest or detention on account of the war. Blacks first. In most countries of continental Europe, passports are given to travelers. These are intended to protect them on their journey to protect them from all molestation while they are obedient to the laws. The Secretary of State may issue or cause to be issued in foreign countries by such diplomatic or consular officers of the United States, and under such rules as the President may prescribe, passports, but only to citizens of the United States. Bouvier's 8th. See vessel. Note, a passport is issued to, quotes, a vessel, that is to say, a citizen of the United States. Trade name in times of war. The U.S. government officially declared war on all citizens of the United States, persons in the Amendatory Act of March 9, 1933, also known as Emergency Banking Relief Act, to the Trading with the Enemy Act of October 6, 1970. See Monopoly. Pay is a verb. To discharge a debt by tender of payment due. To deliver to a creditor the value of a debt, either in money or in goods for his acceptance. UCC 2-511. UCC 3-604. Black 6th edition. See payment or redemption. Payee in mercantile law. The person in whose favor a bill of exchange, promissory note, or check is made or drawn. The person to whom or to whose order a bill, note, or check is made payable. Blacks first. See note. Payment. The fulfillment of a promise or the performance of an agreement. A discharge of an obligation or debt. In a more restricted legal sense, payment is the performance of a duty, promise, or obligation, or discharge of a debt or a liability by the delivery of money or other value by a debtor to a creditor, where the money or other valuable thing is tendered and accepted as extinguishing debt or obligation in whole or in part. Also, the money or other thing so delivered. UCC 2-511, UCC 3-604, Black's 6th edition. See redemption. Payment intangible. Payment intangible means a general intangible under which the account debtor's principal obligation is a monetary obligation. UCC 9-102A61. Pecuniary, of or relating to money, monetary, Black 7th. Peonage, the condition of a peon, formerly a debtor kept in virtual servitude until he had worked out his debt. So the condition of a peon, or the system of employing this form of labor, Funk and Wagnall. To perfect is a verb. To legally establish. Security interest in collateral is perfected when a document describing the collateral is entered into the records of the UCC office. Perfection of security interest In secured transactions law, the process whereby a security interest is protected as far as the law permits against competing claims to the collateral, which usually requires the secured party to give notice of the interest, as by filing in a government office, for example, the Office of Secretary of State. Perfection of a security interest deals with those steps legally required to give a secured party interest in subject property against debtors' creditors. Black 6th. A security interest is perfected when it is attached and when all the applicable steps required for perfection have been taken. Such steps are specified in sections 9-302, 9-304, 9-305, and 9-306, the UCC. If such steps are taken before the security interest attaches, it is perfected at the time when it attaches. UCC 9-303, section 1. See attach. Person was a noun, from Latin persona, said to be compounded of per, through or by, and sonus, meaning sound, a Latin word signifying primarily a mask used by actors on the stage. Persons are divided by law into natural and artificial. Natural persons are such as the God of nature formed us. Artificial persons are such as we created and devised by human laws for the purposes of society and government, which are called corporations, or bodies politic. Blacks first. Persons of two kinds, natural and artificial. In law, a human being is called a natural person. Artificial persons include a collection, corporation aggregate, or succession of natural persons, successive office holders in a corporate soul, forming a corporation. Blacks fourth. In law, an individual or incorporated group having certain legal rights and responsibilities, this has been held to include foreign and domestic corporations. Precise definition and delineation of the term has been necessary for purposes of ascertaining those to whom the 14th Amendment to the U.S. Constitution affords its protection, since that amendment expressly applies to persons. Barron's third. See note. Note, the trade name is a person, a mask, for the sentient living being who uses it. The trade name is a fictitious person whose name is written in legalese, that is to say, a language foreign constructed outside the bounds of English grammar. The true names of men and women written properly, that is to say, initial letters only capitalized, are sometimes called natural persons. However, it is just as impossible for the person to be natural as it is for a man to be artificial. Person is a moniker hatched by lawyers, introduced for generating confusion in the mind of non-Esquire victims between the actual and the artificial. See strawman. Pledge. A deposit of personal property is security for a debt, delivery of goods by the debtor to the creditor until the debt is repaid, generally defined as a lien or contract that calls for the transfer of personal property only as security. The pledger can pledge intangible as well as tangible personal property, as long as it is capable of delivery, and it can confer ownership rights upon the person to whom delivery is made. Barron's third. See note. Note, the bankrupt U.S. government pledged your body, labor, and property as the collateral for a loan of credit. Federal Reserve notes. Using your birth certificate, a negotiable document, a document of title, as the security for the loan. Ponzi scheme. A fraudulent investment scheme in which money contributed by later investors generates artificial high dividends for the original investors, who examples attracts even larger investments. Money from the new investors is used directly to repay or pay interest to old investors, usually without any operation or revenue-producing activity other than the continual raising of new funds. This scheme takes from Charles Ponzi, who in the 1920s was convicted for fraudulent schemes he conducted in Boston, Black 7th. Positive law. Law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. Possessory. Relating to possession. Founded on possession, contemplating or claiming possession. Possessory lien. A lien allowing the creditor to keep possession of the encumbered property until the debt is satisfied. Black 7th. See UCC 9-333. Priority of certain liens arising by operation of law in this glossary. Note, the new security agreement in this manual evidences a possessory lien or a common law lien, certain collateral giving the secured party right of possession of every such item of a debtor's property until the obligation is satisfied. A possessory lien has priority over a security interest in goods. Post liminem. A fiction of the civil law by which persons or things taken by the enemy were restored to their former status on coming again under the power of the nation to which they formerly belonged. Bouvier's 8th. Post limine. The right of post limine, says Vattel, is that in virtue of which persons and things taken by the enemy are restored to their former state on coming actually into the power of the nation to which they belong. Post limine is defined to be the principle of the law of nations under which property, if taken by the enemy in time of war, is restored to its former state upon coming again under the power of the nation to which it formerly belonged. Preferred. Possessing or accorded a priority, advantage, or privilege, generally denoting a prior or superior claim or right of payment as against another thing of the same kind or class. Black's 4th. See stock. Presentment. 2. A formal written accusation requested by a grand jury on its own initiative without a prosecutor's previous indictment request. A grand jury has only two functions, either to indict or return a no bill. The Constitution speaks also of a presentment, but this is a term which, with a distinct historical meaning, not well understood. Historically, presentment was the process by which a grand jury initiated an independent investigation and asked that a charge be drawn to cover the facts should they constitute a crime. With United States attorneys now always available to advise grand juries, proceeding by presentment is now an outmoded practice. 3. The formal production of a negotiable instrument for acceptance or payment. Presentment and dishonor occur, for instance, when the holder of a check attempts to cash it at the drawee bank, but payment is refused because the drawer lacks sufficient funds on deposit. The demand for payment is the presentment. The banker's refusal to pay is dishonor. Presentment means a demand made by or on behalf of a person entitled to enforce an instrument to pay the instrument made by the drawee or the party obligated to pay the instrument, or in case of a note or accepted draft payable at a bank to the bank, or to accept a draft made to the drawee, UCC 3-501A, may be made by any commercially reasonable means, including an oral, written, or electronic communication, is effective with the demand for payment for acceptance is required by the person to whom the presentment is made, UCC 3-501-1. The production of a negotiable instrument or bill of exchange to the drawee for his acceptance, or to the drawer or acceptor for payment of a promissory note to the party liable for payment of the same. Presentment is a demand for acceptance or payment made upon the maker, acceptor, drawee, or other payor by or on behalf of the holder. UCC 3-504-1, Black 6th. See note, summary proceeding. Notice that the identical terms are used in the definitions when speaking both of criminal matters and financial commercial matters. In criminal matters, a bill, called a true bill, is issued by the grand jury. A bill is the list of charges, both criminally and financially. A true bill is a list of charges that is sworn, true, correct, and complete affidavit. In financial matters, a presentment can only be one of the following. 1. A demand for payment of a negotiable instrument, or 2. A demand for acceptance, that is to say, of responsibility for payment and performance of a negotiable instrument. Presumptions, nature. Except as otherwise provided in Section 1.202, the presumptions established by this code are presumptions affecting the burden of producing evidence. UCC 1-210. Presumption. A presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. A presumption is not evidence. A presumption is either conclusive or rebuttable. Every rebuttal presumption is either A, a presumption affecting the burden of producing evidence, or B, a presumption affecting the burden of proof. Black 6th. A disputable presumption, called also an inconclusive or rebuttable presumption, is an inference of law which holds good until it is invalidated by proof or a stronger presumption. Black 4th. See note. Note. In reference to ownership of your trade name, a presumption of ownership was made and title thereto, the birth certificate, was taken without knowledge and consent of both your mother and you. Such presumption is nullified via the publication of a copyright notice under common law, and is further amplified with the filing of a UCC financing statement. Priority, precedence, going before, a legal preference or precedence. When two persons have similar rights in respect of the same subject matter, but one is entitled to exercise his right in the exclusion of the other, he is said to have priority. Black's 4th. Private bank, an unincorporated banking institution owned by an individual or partnership and demanding or depending on state statutes, subject to or free from state regulation. Black's 1st. See banker. private banker. A private banker is one who conducts the business of banking without incorporation and without any special privilege or authority of law. Perkins v. Smith, 116 New York, 441. People v. Doty, 18 New York, 225. A private banker may, when not prohibited by law, conduct the business of banking, and may make such lawful contracts with his dealers in the relation thereto as to receiving and the repayment of money, as may be mutually agreed upon between the parties. A private banker, then, is one who conducts the business of the banking without incorporation or a fixed capital stock invested, which is by law required of all duly incorporated banks, excepting mutual savings banks, which under the law, as enacted by some of the states, may become incorporations for the purpose of doing a savings bank business without capital stock. Note: per 31 United States Code 5312 A2C, every private individual is a financial institution and a private banker. In Bank of Augusta versus Earl, there's your stuff. The court ruled a private individual has as much privilege as banks. Prize in admiralty law. A vessel or cargo belonging to one of two belligerent powers, apprehended or forcibly captured at sea by a war vessel or privateer, or the other belligerent, and claimed as enemy's property, and therefore liable to appropriation and condemnation under the laws of war. Blacks first. Note: prize on a land is called booty. Prize law. The system of laws and rules applicable to the capture of prize at sea, its condemnation, rights of the captors, distribution of the proceeds, etc. Blacks first. Moving along. Proceeds. Proceeds, except as used in subdivision B of section 9609, means any of the following property. A. Whenever is acquired upon the sale, lease, license, exchange, or other disposition of collateral. B. Whatever is collected on or distributed on account of collateral. C. Rights arising out of collateral. D. To the extent of the value of the collateral, claims arising out of the loss, nonconformity, or interference with the use of, defects, or infringements of rights in, or damage to the collateral. E. To the extent of the value of the collateral and to the extent payable to the debtor of the secured party. Insurance payable by reason of the loss or nonconformity thereof. Defects or infringements of rights in, or damage to the collateral. UCC 9-102A64. Anything that is used to guarantee the payment of a loan or the fulfillment of some other obligation. Promise to pay. Promise means a written undertaking to pay money signed by the person undertaking to pay. An acknowledgement of an obligation by the obligor is not a promise unless the obligor also undertakes to pay the obligation. UCC 3-1039. Promissory note. Promissory note means an instrument that evidences a promise to pay. A monetary obligation does not evidence an order to pay and does not contain an acknowledgement by a bank that the bank has received for deposit a sum of money or funds. UCC 9-102A 65. A note. A kind of negotiable instrument wherein the maker agrees promises to pay a certain sum certain at a definite time. Barron's 3rd, see note. What they, that is to say the banks, do when they make loans is to accept promissory notes in the exchange for credits to the borrower's transaction accounts. That's from Modern Money Mechanics, page 6, Federal Reserve Bank of Chicago, 1992. Note, promissory note is synonymous with note. The last section of the first definition above tacitly acknowledges that a borrower's promissory note constitutes funds and monies. Banks do not loan substance. Per banking regulations and generally accepted accounting principles, banks are forbidden from loaning the bank's assets and likewise the assets of the bank's depositors. As confirmed in the above excerpt from Modern Money Mechanics, the signed promissory note constitutes the sole source of the funds that are loaned for the benefit of the borrower. No substance is loaned. The so-called transaction account referenced in the above excerpt from Modern Money Mechanics goes on the bank's books exactly as a demand deposit, checking, saving, passbook, time account would. The borrower, customer, or actually the lender and creditor of the bank is actually the borrower and debtor of the customer. The bank issues a pretend loan, which is actually the borrower's depositor's own funds taken from the transaction account created upon the borrower's customer's execution of a promissory note and the bank's subsequent deposit of the promissory note, the money in the account. See House Joint Resolution 192 of June 5, 1933. Proper. Grammar. Of a name, noun, or adjective designating a particular person or thing written in English with an initial capital letter. John, Chicago, Monday, American. In grammar, used to designate a specific individual, place, etc. Donald, Rover, Boston, etc. are proper nouns written with the initial capital letter. Note, a true name has an initial capital letter only. There is no provision in the rules of English grammar for the proper nouns to be written any other way, including all capital letters format. An all capital letters name is a legal artifice existing only by force of or the contemplation of law. See capital letter, all caps, letters written, artificial. Propria persona. See propria persona, meaning proper person. Proposal. Proposal means a record authenticated by the secured party that includes the terms on which the secured party is willing to accept collateral in full or partial satisfaction of the obligation it secures pursuant to sections 9620, 9621, and 9622. UCC 9-102A 66. Protest. A notarial act, being a formal statement in writing made by a notary under his seal of office at the request of the holder of a bill or note in which such bill or note is described and is declared that the same was on a certain day presented for payment or acceptance as the case may be, and that such payment or acceptance was refused, and stating the reason, if any, given for such refusal, whereupon the notary protests against all parties to such instruments, and declares that they will be held responsible for all loss or damage arising from its dishonor. Blacks first. Prove. Prove, with respect to a fact, means to meet the burden of establishing the fact. Subdivision 8 of Section 1-201. UCC 3-10310. Public, adjective, pertaining to a state, nation, or whole community, proceeding from, relating to, or affecting the whole body of people or an entire community, open to all, notorious. Common to all or many, general, open to common use. Belonging to the people at large, relating to or affecting the whole people of a state, nation, or community, not limited or restricted to any particular class of the community. Black 6, that vast multitude, which includes the ignorant, the unthinking, and the credulous, who in making a purchase do not stop to analyze, but are governed by the general appearance of the general impression. Valentine's Law Dictionary. Public corporation. Public corporations are those which are exclusively instruments of the public interest. Bouvier's 8th. An artificial person created for the administration of public affairs. Unlike a private corporation, it has no protection against legislative acts, altering or even repealing its charter. Instrumentalities created by state, formed and owned by it in public interest, supported in whole or in part by public funds, the governed by managers deriving their authority from state. Black 6, see note. Public debt, that which is due or owing by the government. Bouvier's 6th. Public enemy, this word, used in the singular number, designates a nation at war with the United States, and includes every member of such nation. To make a public enemy, the government of the foreign country must be at war with the United States. For a mob, however numerous it may be, or robbers, however they may be, are never considered as a public enemy. Bouvier 6, see note. Note, declared public enemies of the United States are, by definition, citizens of a foreign country or nation. Public law, that branch or department of law which is concerned with the state and which, in its political or sovereign capacity, including constitutional and administrative law, and with the definition, regulation, and enforcement of rights in cases where the state is regarded as the subject of the right or object of the duty, including criminal law and criminal procedure, and the law of the state, considered in its quasi-private personality, that is to say, as capable of holding and exercising rights, or acquiring and dealing with property, in the character of an individual. Black's 1st, see note. Note, if the term state is meant to designate a government associated with a collective body politic, it is a fictitious entity and therefore cannot be sovereign. In Juilliard v. Greenman, 1884. The Supreme Court states, quotes, Congress can exercise no power by virtue of any supposed inherent sovereignty in the general government. Indeed, it may be doubted whether the power can be correctly said to appertain to sovereignty in any proper sense as an attribute of an independent political community. The power to commit violence, perpetrate injustice, take private property by force without compensation to the owner, and compel the receipt of promises to pay in place of money may be exercised, as it often has been, by irresponsible authority, but it cannot be considered as belonging to a government founded upon law. But be that as it may, there is no such thing as a power of inherent sovereignty in the government of the United States. The fact that Blacks states, thus quotes, the state is the state in its sovereign capacity, unquote, tacitly confirms that every man and woman is a state, as only a real being with free will can be sovereign. Public policy. 1. Broadly. Principles and standards regarded by the legislature or the courts as being or fundamental concern to the state and the whole of society. Courts sometimes use the term to justify their decisions, as when declaring a contract void because it is contrary to public policy. 2. More narrowly, the principle that a person should not do anything that would tend to injure the public at large. Black 7th. Community common sense and common conscience extended and applied throughout the state to matter of public morals, health, safety, welfare, and the like. It is that general and well-settled public opinion relating to man's plain, palpable duty to his fellow men, having due regard to all circumstances of every particular relation and situation. Black 6th. Public policy is manifested by public acts, legislative and judicial, and not by private opinion, however eminent. It is said to be determined from legislative declarations, or in their absence from judicial decisions. Bouvier's 8th. See note, public law. Note, a general concept taking in the whole of society considered as a single abstract collective entity, as contrasted with the same benevolent principles applied on behalf of individual members of society. The public cannot be harmed, only individual men and women can be harmed. Since Erie Railroad versus Tompkin in 1938, shortly after the declared bankruptcy of the United States government, we have had only public policy, but not public law. The above definition from Black's 6th of 1990 cannot be found in Black's 4th of 1957, which was printed at the time the subject of the public policy was being implemented and replacing public law. That is to say, the switch has taken place and the institution of public policy is now entrenched. For example, as well as the UCLA School of Law, there is also a UCLA School of Public Policy and Social Research. Look around and see for yourself. Public property, that which is dedicated to the use of the public, and or that over which the state has dominion and control. Thus the term may be used either to describe the use to which the property is put, or to describe the character of its ownership. Public vessel, one owned and used by a nation or government for its public service, whether it is navy, its revenue service, or otherwise. Black 6. See note. Note, your corporately colored trade name may be construed as a vessel, a public vessel, and is used by the U.S. government in its revenue service and otherwise. See vessel. Purchase. Purchase includes taking by sale, discount negotiation, mortgage, pledge, lien, issue or reissue, gift, or any other voluntary transaction creating an interest in property. UCC 1-20132. The term purchase includes all contract to purchase or otherwise acquire. Security Exchange Act 3. See note. Purchase. Money, security interest. Purchase, money, security interest. A security interest which is created when the buyer uses the money of the lender to make the purchase and immediately gives to the lender a security interest. UCC 9-107. Compare security interest. See note. Note, when you borrow to purchase a new automobile, the purchase money for the car comes from the lending bank. The lending bank is listed on their certificate of title as lien holder. This is a designation of the lending bank's purchase money security interest in the car. The funny thing is, however, when the loan takes place at a Federal Reserve member bank, The money of the lender does not come from the, quotes, lender or the bank. It comes from the borrower. Banks do not loan their own money. That is to say, no account belonging to the bank is debted in the loan transaction. The banker does a banker's acceptance of the borrower's promissory note, that is cash, and loans it back to the borrower at interest. Quote, what they, the banks, do when they make loans is to accept promissory notes in exchange for credits to the borrower's transaction account. Modern Money Mechanics, page 6, Federal Reserve Bank of Chicago, 1992. And from there, we are done with the O's and P's. Thanks for listening to this section of the glossary and Cracking the Code 3rd edition. We'll get back to you soon.